So these are the oral arguments today that have to do with whether or not Donald Trump can shield himself from all criminal liability by saying that because he was the president, he should have broad immunity. The president should have broad immunity from every single criminal charge. Oof. It's likely going to be remanded back to the lower court to determine if Trump acted in an official capacity or not. Yeah, I feel like that's an even harder question to answer, right? Because what counts as official capacity as president?
Mr. Chief Justice, and may it please the court. Without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts.
If it isn't live and there's no news about it, it doesn't seem like nothing came from it. Well, I think usually oral arguments will point in the direction of what the all the justices are kind of thinking.
The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face the biggest question here, in my opinion, is how do you hold a president accountable once they've left office? That seems, my layman's understanding is, that seems to be the thing that nobody understands right now. Because on Donald Trump's last impeachment, which was over the January 6th stuff, the big reason why a lot of people didn't vote to convict in the Senate was because they felt like impeachment was an improper procedure to go through for somebody that was no longer president. That if you're going to impeach a sitting president, he needs to be a sitting president. You can't impeach somebody that's no longer in office. However, now that Trump is out of office and facing a multitude of criminal indictments, now the argument has switched back to, well, actually, the only way to hold a president accountable is through impeachment and not through the courts. Impeachment is the proper process to hold a president accountable for their actions while president, and the criminal courts are not proper. Now, obviously, the weird part of this is that, okay, so does that mean, and it's funny because I gave what I considered to be a really extreme hypothetical on stream, and I think that same extreme hypothetical was asked in a lower court, which essentially says, could the president order SEAL Team 6 to assassinate all of his political rivals and not be held criminally responsible for it? And the answer that I think it was John Saar, he said, yes, you could do that. If you want to hold that president accountable, they have to be impeached. They can't be charged in criminal court for any action ever, that's extreme. It doesn't make it wrong, but it's a very, very, very interesting predicament / dilemma / whatever. One of the things that's interesting as we go through this, and as we've noticed in the United States system, and probably in every system around the world, is institutions and systems are probably only as good as the people that inhabit them, and that if you have bad faith actors moving or utilizing your system, you can break it in surprisingly unhinged ways, which is what we might be seeing with how Donald Trump is acting, essentially. Make it quick because I haven't read any of these or listened to any of these, so if you're about to spoil all the oral arguments, we haven't got through yet. But if you want to comment on something I just said, go for it.
Yeah, just real quick. It's interesting because the SEAL Team 6 stuff does make an appearance today. They do talk about a little bit more about that. So that's an interesting thing to keep in mind when we're talking about this. But yeah, that's all.
Okay, love you. Bye.
All right, take it.
The weirder part is actually they have to convince a group of retards all of this, jurors at Destiny. Nope. Well, right now the question of whether or not a president can be held criminally liable is a question before the Supreme Court. That's not that a jury won't decide that because it's a matter of procedure, which is what the Supreme Court essentially decides, right? Destiny. Trump was impeached while he was in office. The first one was. The second one he wasn't. He was impeached twice, remember? If this is ruled in Trump's favor, would you be able to criminally charge a president after impeachment? I don't know. I don't know
I feel like the process of impeachment in the United States only allows for the removal of office. I don't think it actually allows for any other penalties. But let's check real quick. I'm not sure. The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. I don't believe there are any other penalties set out in an impeachment process. I don't believe so. Destiny, Trump was impeached the second time while in office. I don't know what you want me to say. Donald Trump's tenure as the 45th president of the United States began with his inauguration on January 20th, 2017, and ended on January 20th, 2021. The second impeachment trial of Donald Trump, the 45th president of the United States, in office from 2017 to 2021, began on February 9th, 2021, and concluded with his acquittal on February 13th. I don't know what I'm supposed to say to you. I don't know what you want me to say to you. As a normie with no knowledge, wouldn't the courts want to side with Trump, since it seems as if a president of past presidents being liable to get charged for crimes in office, but I'm just a retard? No, that's a good question. And the idea, January 13th is in the next sentence. What do you want? Donald Trump had been impeached for the second time by the House of Representatives on January 13th, 2021. The House adopted one article of impeachment against Trump, incitement of insurrection. He's the only U.S. president and only federal official to be impeached twice. He was impeached by the House 7 days prior to the expiration of his term in the inauguration of Joe Biden because he left office before the trial. This is the first impeachment trial of a former president. What did I say earlier in my stream? What did I just say? Didn't I say earlier that the people that acquitted him in the Senate said it was because he was already out of office? Is that did I not specify Senate? I mean, the vote goes to the Senate next. Like, stop typing. Say something. We're not here to watch you type all day, you fucking loser. Oh, cool. Wow, nice typing stream. Nice. Good one. Wow. What are you typing at? Were you working on a fucking novel over here? Holy shit. Trump was impeached while he was in office. The first one was. The second one he wasn't. He was impeached twice, remember? Give general thoughts on what's about what? I had fun. It's fun times. What am I looking for? Good job, dumbass. They wanted more details for that. Say something more specific. Oh, more typing. Wow, cool. Do you agree with the arrest of the protesters? Yeah, 100%. They should have all been kicked out. It's private property. What is he even looking at right now? What the fuck is he even looking at? What is he doing? What is he clicking so much on? Show us. If this is ruled in Trump's favor, would you be able to criminally charge the president after impeachment? I don't know. I feel like the process of impeachment in the United States only allows for the removal. Okay, I don't know. Okay, anyway, I don't even know why I'm arguing this. We read through the statements that were given by a lot of Republicans in the Senate, and a lot of them said, I think it was 11 of them. Do we have this anymore? It was 11, or it was enough that he would have been impeached in the Senate as well. But they said, we don't want to impeach Trump. We're not going to vote in favor of this. Even though we agree on the merits, we're not going to do it because we just don't think that we can impeach a non-sitting president. It doesn't make any sense. We read all these on stream. I don't know why I'm even arguing about this guy or with this guy. Wow, Edmund, thanks for the 12 or $50, dude. Have a thumbs up. I don't know how to. Oh, I can heart you though. There you go. Boom. You won the heart. How significantly does the legal understanding of senators impact legal precedent? I don't know, because like the court is, or the Congress is like a quasi-legal body. I don't know what the jurisprudence or like the legal theory is behind the functioning of Congress as a court, because in some ways Congress kind of like plays as a court, or they use a lot of similar terms and a lot of similar kind of processes. Like you'll have like a Senate inquiry panel where people will be under oath. I think you can depose people for like congressional hearings and stuff. So in some ways it's kind of similar, but I feel like it also kind of exists a little bit independent of, like, I don't know if it like informs legal stuff. Like, I don't know if a court ever says like, well, in Congress they did it like this, so this is like the new precedent or something, you know? Will you start pronouncing flaccid as flaccid? God, I've been running into more people in my life who pronounce aesthetic. And God, it drives me fucking crazy. Aesthetic? Anyway, sorry. I believe for impeachment, the only thing it does is allows you to remove somebody from office. I don't believe there are any
criminal penalties after that. Okay, sorry. There we go. Do women prefer length or girth? When you're 10 by 10 like me, it doesn't matter.
Mr. Chief Justice, and may it please the court. Without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty.
One of these arguments, these appeals to historical norms, in some ways are very important and in some ways are completely irrelevant. It is important that we follow the norms that are before us or that have come before us. Well, it's kind of interesting that before can mean past and future, right? Like what's before us today could mean like the present or what's in the future, and like the things that have come before us are things in the past. Interesting. But anyway, yeah, you don't want to step out of line of like, well, what is the legal precedence for the country? What are the historical norms for the country? But I think you also have to be very careful not to fall into this trap of, well, we've never done this before, but what if you're genuinely coming against a situation that is actually unprecedented? An unprecedented situation might call for an unprecedented ruling or application of law, which is unfortunately where we're at with Donald Trump, because there have been unprecedented actions that have taken place. So the question is, what's the appropriate way to deal with these? And appealing to history, I think, is kind of unsatisfactory in some ways, because it's like, okay, sure, we've never done these particular things before, but also a president has never done these particular things before. Or at least it's my understanding that in the United States of America, you've never had a president try to circumvent the peaceful transfer of power in such an obvious way. This just hasn't happened before.
If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed.
This is the strongest argument for immunity, is that when the president is operating in matters of the executive for the United States, the last thing that you want a president thinking about, maybe, is if I take this action that I believe is in the best interest of my country, am I going to face a criminal court later on, right? Now, I just said that and I immediately don't know if I even find that argument compelling. I think for a couple of reasons. One, maybe you should think about like, well, what are the personal responsibilities I have here, and could I be held criminally liable for it? And two, I feel like the people that use this argument the most, like the types of people that are supporting Trump, are the same types of people that say Obama should have been criminally prosecuted for having that American citizen drone struck, or Bush should be held criminally liable for war crimes. So yeah, I'm not sure how many people even actually feel this, that support this argument. Now, that's not a counter to the argument itself. Rather, that's an ad hominem, or it's an attack. No, it's not really an ad hominem. It's an argument to hypocrisy of the people that are supporting it. So it doesn't really contradict the argument itself, but something to keep in mind that a lot of people that say the president should be able to operate broadly with immunity from criminal prosecution seem to really want criminal prosecution when it's politicians they don't like. But
Could President Obama be charged with murder for killing U.S. citizens abroad by
he brought up the
drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies?
Another thing that I really don't like about this argument, and I feel like Esports Batman said this might be what it gets kicked back to the courts on, and I hate this because I feel like I know how it's going to go. Another thing that I really don't like about this argument is let's think about what was just said. Okay, what were the three examples that were brought up? We have Obama drone striking American citizens in other countries. We've got Bush lying to the American public to go to war in Iraq. And we've got Joe Biden inviting illegal immigrants to come to the country, okay? One thing, this argument gets brought up a lot, that future politicians and future presidents might be held to account for actions that they take politically. But one thing I don't like about that argument is that when we look at these three actions, all of these seem to be pretty clearly like a president operating in the capacity as the president of the United States. Donald Trump's actions, I think, are clearly more self-serving. I think we get into a clearly different type of thing, that when we are personally invested in things of voter fraud,
when we are personally invested in things relating to like Zelensky and op-ed research, I think that in this capacity, I think that Donald Trump is not clearly acting in the capacity as the chief executive, more so that he's acting in the capacity of somebody running for office again and trying to secure his future election. Now, the arguments against this is, okay, well, how can you ever clearly tell, right? Like, what if George Bush, so we can go through each of these, what if Obama thought that he needed to strike that American citizen because he, the Obama one is really hard to do. We won't think of that. For the Bush one, what if the reason why Bush lied to the American public because he wanted to go to war in Iraq was because he wanted to win re-election? He thought that a wartime president, more likely to get reelected. He wasn't sure if he'd win without it. So he did that largely to secure a re-election, right? So maybe Bush is doing it for personal reasons. Or what if Joe Biden is inviting illegal immigrants, not acting in the capacity as the president of the United States, but what if he's doing that because he thinks that he genuinely believes that having more of these people in his country will win him more favor of the citizens, and now he'll get reelected, right? So these are two examples where, well, you say that it's so clear that the president is operating in the capacity of the president, that he's doing things for the American public, but it might just be self-serving, right? And then much the same on the bottom, we could say, okay, well, Donald Trump being invested in voter fraud, I mean, if voter fraud is actually happening, why would you not want that investigated for the bettering of the American people? This isn't Donald Trump acting selfishly. This is him protecting our election system, which is arguably one of the most important jobs of the entire system itself, to maintain the credibility of it. And in terms of Zelensky and doing research into, potential corruption of politicians' children, why would this not be something that the United States president would be, chiefed with doing? He has the ability to negotiate with and communicate with foreign leaders. Why would he not make this request? That could be done in the capacity as president as well. Now, the Esports Batman spoiled and said that apparently it looks like the court might kick it back to the lower courts and force them to deal with that question. Meaning maybe they're going to have to decide then, what does it mean to act in the capacity as president versus acting personally? But that's almost impossible. That's going to be an almost impossible thing to actually delineate. Or it would have to be something that would be decided on a case-by-case basis in court, right? So, but we'll see how this gets brought up. What is the constitutional basis for such a personal reasons exemption to presidential conduct? I'm not going to be able to tell you exactly where it comes from by letter of the law, but I believe that the legal theory is that the reason why you can't hold a president criminally liable is because actions that the president does are supposed to be done as the president, and if you want to hold him liable for things he does as president, then the process to do that is impeachment. That's it. You can't hold him personally responsible. He's the president of the United States. Why would you personally indict him or criminally charge him for things that he's doing in capacity as the president of the United States, essentially? I don't know where exactly from the Constitution that argument, but I believe that's the broad legal theory around it. So, what's the reason for not letting cameras inside the Supreme Court? I have no idea. Tradition?
I welcome the court's questions.
Mr. Sauer, to your last point, could you be more precise as to the source of this immunity?
Okay, so important question, the source of the immunity. So where in law or where in legal history in the United States or where in the Constitution does the president draw this immunity from? Do we have an answer here besides tradition? And this is Thomas that's asking the question. This is a cute little VR setup.
The source of the immunity is principally rooted in the executive vesting clause of Article 2, Section 1.
And how?
Okay, Article 2, Section 1. Let's read. Constitution. Clause 1, President's role. Article 2, Section 1. It'll be just here, right? I think. Just in... The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and, together with the Vice President, chosen for the same term, be elected as follows. This is, when it says like Clause 1, Clause 2, Clause 3, this is all the text of the Constitution, right? This isn't like a redacted or edited fucking version or any bullshit, right? Okay, so he's citing the... broadly just the function and role, I guess, of the president here is going to be his source. And obviously the text here is not very satisfying. So I imagine there's going to be like historical argument that he's going to use to satisfy Thomas's questions here. But let's see.
Source of the immunity is principally rooted in the executive vesting clause of Article 2, Section 1.
And how?
Hold on. Destiny, does this immunity mean that presidents can do whatever they want towards the end of their term? Yes, that would be one of the implications. Correct. He's talking about the vesting clause. That's this one right here. That's this clause, right? Clause 1.
Does that happen?
Sorry, let me answer
The
this.
executive vesting clause of Article 2, Section
And
1.
how does that happen?
Yeah.
The source of it, Justice Thomas, I think is, as you described in your separate opinion in Zivotofsky, for example, that the executive vesting clause does not include only executive powers laid out explicitly therein, but encompasses all the powers that were originally understood to be included therein. And Marbury against Madison itself provides strong evidence of this kind of immunity, a broad principle of immunity that protects the president's official acts.
I don't know if they get the questions ahead of time. I'm guessing they don't, right? That you would know the questions they're going to ask ahead of time, or maybe you'd have a rough idea of what they would ask ahead of time. I want to comment and say like, oh, this is a nice way to answer the question, but I truly don't know any of the precedent. So keep in mind that when I say all of this is coming from like a layman, I don't know, but I feel like it's good. It feels good. Hopefully, I don't know if it's like a faux pas that he responds to Thomas's question with, oh, well, I'm actually going to cite to you a ruling and an opinion that you've actually penned on a case saying that this is the type of power vested of the president or whatever. Although I guess it's a double-edged sword because if he disagrees with how you're citing his opinion, it's not going to be like a Finkelstein v. Benny Morris thing where you get to argue against Benny Morris about what his quote meant. It just means that the justice is going to disagree with you and you're going to get fucked. But yeah.
What an official act is.
I point the court to two cases for that. Obviously, Fitzgerald against Nixon is the best guidance that the court gives, where the court adopted the outer perimeter test. And this court engaged in analysis there that's very instructive here, where it looked at the level of specificity at which the acts are described. In that case, a civil case. Here it would be the indictment.
Well, what if you have, let's say, the official...
So Thomas asks a good question here in that, okay, well, you're citing, so also a narrowing question, right? There's a narrowing of, well, you're saying that the president has immunity based on what I've said relating to official acts. Well, what is an official act? Now, I imagine that Trump's lawyers are going to want to argue that as broadly as possible. Everything a president does is an official act. He's the president, obviously. You can't possibly separate a personal and a presidential act while he's president at least. Right? That's going to be the argument. And Thomas is asking a more narrow, or he's trying to see if you can narrow that. How do you determine what is or isn't a presidential act, right?
That case, a civil case. Here it would be the indictment.
Well, what if you have, let's say,
Who's
the
talking
official
now?
act is appointing ambassadors, and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
Okay, that's a good question. So Robert says, yeah, okay, well, fine. President appoints somebody. That's his official power as president, but he does it by taking a bribe. So Sauer, is it Sauer? Is that how you pronounce this guy? I imagine the response is just, well, then you would impeach him, right? But there's no criminal charges whatsoever for that.
That, I think, would fall under this court's discussion in Brewster, where the court held with respect to legislative acts that bribery is not an official act, which also matches the common law background. So the way that this court in Brewster...
Oh, interesting. Okay, so Sauer's not going to argue super broadly. He's going to say there are some things that are official acts and some things that aren't. So taking a bribe is not an official act.
kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct. Or
Okay,
subsequent appointment would be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
It's not, accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So
what are these graphics? For the Supreme Court, I don't know why. Probably it's just a tradition thing. You're not allowed to take any video stuff into the Supreme Court, but you are allowed to make audio recordings. So CNN or MSNBC did a live little like VR Roblox fucking thing, whatever the fuck you'd call it, to show you who's talking when, because we don't have video of what's going on.
appointing an ambassador is certainly within the official responsibilities of the president. So how could you, how does your official acts or the official acts boundary come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson.
Oh, no federal courts allow cameras. Sorry.
Whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively at least, in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official. You say, okay, we're prosecuting you because you accepted $1 million. They're supposed to say, not say what it's for, because the what's for part is within the president's official duties?
There has to be, we would say, independent source of evidence for that. And keep in mind that this indictment charges...
So Roberts, I think Roberts is saying like, okay, well, fine, then we can't refer to what the president's official job is, but then how do we call that a bribe? We can't refer to him appointing an ambassador because that's his job, but we refer to him taking a bribe, but we can't talk about what for the bribe is. Like, how does that make any sense? And yeah.
Has to be, we would say, independent source of evidence for that. And keep in mind that this indictment charges what this court has described as unrestrictable powers of the president. So the premise, the logical premise of this indictment is that Congress, by passing vague and general criminal statutes, has purported to directly regulate the president's exercise of things like the exercise of the appointment and removal power, things like his ability to speak directly to the American public, core exercises of his authority under the Recommendations Clause to recommend to Congress, members of Congress, the measures he thinks necessary.
I don't like that he went broader there when Roberts was asking a specific question, but maybe you're allowed to yap in here.
And expedient. So you have an indictment in this case that goes right to the heartland of the president's powers, that alleges a whole series of official acts and tries to tie them together by saying, well, there's a private aim or a private purpose in that case. And that's a situation which, of course, could be alleged in virtually any indictment.
Counsel, it can...
So Sauer is saying that, like, okay, well, there's a whole bunch of public things that Donald Trump has done that they don't like for political reasons. And if you can tie, and they're trying to tie that to a private thing that we would say is like criminal in nature, well, you could tie any broad number of public acts as president. You could tie any of those to anything public in nature. So you can't do this. You'd essentially have every single president being indicted and charged for crimes at all points in time. It would make the job of the president impossible.
Counsel, it can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamental viewed as appropriate in law, that there's some things that long proven. Malum in se is...
Malum in se, what is that? What is that, Latin? I'm not going to be able to... Oh, malum in se is a concept in criminal law referring to an inherently immoral act, regardless of whether the action is criminalized. Common examples of malum in se actions include arson, murder, and rape. Malum in se offenses are usually based on common law crimes where a specific intent requirement is incorporated into the definition of the offense. Oh, interesting. So this is almost like a... I'm curious. This almost sounds like in international law. We call this a... is it jus cogens? Where there are some things that are just like, these are just like horrible bad things that everybody cannot do. You can't make a treaty for it. They're just obviously like, it supersedes even what you would call like customary international law, because for some customary international law where everybody kind of agrees to do things because they think they have to, you can make treaties around it. For these jus cogens things, you can never get around these. You can't rape people. You can't murder people. You can't do genocide, but you can never get around these things. There are certain forms of legal action that can never be justified by or put beyond the range of legitimate complaint by the prior illegal action of another state, even when intended as a reply to such action. These are acts which are not merely illegal, but malum in se, such as certain violations of human rights, certain breaches of the laws of war, and other rules in the nature of jus cogens, that is to say, obligations of an absolute character, compliance with which is not dependent on corresponding compliance by others, but is requisite in all circumstances unless under stress of literal vis major. I don't know what this means. Maybe like you're about to be killed or something, but okay, yeah, so these are roughly... is a Latin term meaning superior force. Okay, so maybe like if somebody's literally holding a gun to your head and forcing you to do it or something is what he means there. Yeah, but okay, sorry. All right, just curious what that was. Destiny or whoever's in chat, why would the Supreme Court kick back an important case like this to a lower court? Okay, take everything I say with a grain of salt. It might be that a Supreme Court decision on something like this sets an incredibly powerful and awesome like precedent that could change fundamentally the face of all future U.S. political actions. But it might be the case that, well, we could make a broad ruling on presidential immunity, but What if we just ask the lower court to very specifically define what it is they're talking about? Maybe the lower court can make a decision, and then we don't have to actually rule on this. And hopefully it just never comes up again. Might be a thing you would say, right? So oftentimes I say oftentimes, it's not like I've read a million of these cases, but I think that the Supreme Court might not want to make a really big, broad ruling on something like this because of the potential implications of how it could look down the line. And if a lower court can make a more narrow ruling, meaning when I say narrow, I mean it's tailored more specifically to that particular event, and there's not like a huge, broad, a broad standard that's set, that sometimes that's preferable.
It's a concept, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against.
Oh, and this is a good point too, because this goes into the, okay, really? Really? Broad immunity? So should the president be able to murder people? I think that's why she's bringing up this term here.
Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person.
Oh, fuck, this is such a good question. This is the thought experiment that we run on my stream. And then I think Sotomayor, I don't know if she watches on YouTube or Kick. She saw it here. And now the federal courts have been rolling with this hypothetical. It's a good hypothetical.
And he orders the military or orders someone
Let me go back to the beginning of this hypothetical.
that his rival is a corrupt person, and he orders the military or orders someone to assassinate him. Is that within his official acts that for which he can get immunity?
That's such a good question. I'm so curious and I think it was Sauer who kind of answered this before, and he was kind of like, well, maybe, yeah, they could try to impeach him, but that's a pretty crazy, that's a pretty wild answer. Is there an extent to which it can be drawn into unwinnable arguments of semantics, becomes definitional/semantic to the point of stifling/stalemate? No, these are courts with smart people. It's not retarded fucking meme debate shit. Like, judges and these people are the truest professional debaters, and they will arrive at answers that will become law, precedent.
It would depend on the hypothetical, but we can see that could well be an official act.
They could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist.
Oh, nice. Okay, cool. So for the things that I had written down earlier, so she's hitting on these and it feels to me like these three actions that were brought up as examples, like Obama drone striking someone, they seem to be of a far different nature than Trump's actions. It's hard to argue, how could Obama drone striking somebody, how could that be self-serving? That's why I didn't even try to think of like an example, unless he thought the guy was going to run against him for president or something, right? But yeah, it seems like these are fundamentally different in nature.
He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts
as a president
in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we
Harlan,
go back
Johnson,
to Justice Thomas's question, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant immunity to the president.
Ooh, was it Jefferson? There's a quote of like, the president is when an ordinary citizen becomes president, and when the president is no longer president, he returns to being an ordinary citizen. I think that might have been a Jefferson quote. I don't know if that's what she's talking about here, but.
And in fact, they had state constitutions that granted some criminal immunity to governors.
Oof. When she brings up that, so something that's like very scary and is it Sauer? How do you pronounce his name? I really want to get this guy's name right.
can I just Sig Sauer? No, well, is that his name? Is it John Sauer? I just want to hear his name say it.
Actually, I'm going to let Mr. Johnson have our 1 minute
One
here,
time.
but I think he wants to wait for Mr. Kennedy to.
Well, I can be asking of Mr. Sauer.
Okay.
Oh, Sauer. Okay, Mr. Sauer. Okay. So one of the scary things is that if state constitutions said specifically we're giving immunity to him or we're giving limited immunity to him, then the implication there is that, wow, I guess they don't have immunity then unless it's specifically granted, right? So if it was specifically granted, you'd assume it's not. So then your common law or your historical arguments don't work here.
Constitutions that granted some criminal immunity to governors, and yet they didn't take it up. Instead, they pass an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. So, or you can impose criminal liability. We would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake,
but to perform evil personal
more
acts.
than that.
Yeah.
A president is entitled for total personal gain
Yep.
to use the trappings of his office. That's what you're trying to get us to hold.
And there's a very strong argument on the other side, right? There's a very strong argument on both sides of this. On one side, it's, well, hold on, the president could be held to account criminally, de facto blackmail by every single action he takes. Congress could say, well, if you decide to go to war with this country, you better believe I'm going to sue you in court after. You're going to go to war, I'm going to indict you with every single Iraqi citizen that gets killed in this war then, because it was you that ordered it. Criminal conspiracy all the way from the top, right? But on the other end of the argument, it's like, oh, okay, I've got broad criminal immunity. I think that this guy is a threat to the United States. I'm going to start assassinating every single person, and I have to protect the country. I have to kill Joe Biden or Hillary Clinton because they're going to destroy the country. I have to assassinate. That's my job as president, to protect you guys, to keep you safe. That's the argument on their side, right? Both going extreme on either direction is insane. Probably not good. Probably not good. Reductive question, but do you tend to fall on the side of originalism or textualism with respect to the Constitution, or in favor of reforming altogether? I like you read the text. I think I probably like a little bit more of a strict interpretation of the Constitution. You read the text, and if the text gives you a clear answer, then that's the answer. If it doesn't, then you look to the common law or the historical norms when the particular legislation was passed, or what the framers or voters of the amendment or the Constitution said about it. And if there's no answer there, I guess then I don't know, it depends on what you're ruling on. You either kick it to Congress and say, well, make a law, or it's enumerated power. So if there's no clear answer, then the deference goes to the states and the individual, right? Okay.
Trappings of his office. That's what you're trying to get us to hold without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do.
So he's arguing for absolute immunity, but I think he's using arguments for qualified immunity. That qualified immunity is very strong, and that is, however, qualified immunity is probably only as strong as it is because it applies to a narrow set of actions, right? You're giving qualified immunity, meaning that in this person's role, doing the things that an ordinary person would expect them to do in their job, we're not going to hold him criminally liable because of the job he's doing. But that's a narrow set of actions, whereas it feels like for the president, Sauer here wants to argue a very broad set of actions. That very strong qualified immunity is a much different thing than very strong absolute immunity.
Has to be within what a reasonable person would do. I'm having a hard time thinking that creating false.
Is it just me, or just repeating what the judges are saying? You can just go watch it yourself. Or wait, I don't know. Fuck, am I talking too much? I don't know. Here, you tell me. Also, with qualified immunity, there are very specific guidelines and guardrails on what is and what is not in the official capacity. Yeah, it's far more narrow. Okay, fuck you. How much should the court care about the effect of their ruling here when making their decision? Shouldn't they only care about their interpretation of the law as is? Does it really matter if one ruling would lead to crazy outcomes, if it's the outcome supported by the existing rules? There's countervailing forces here. Remember, the court wants to adhere strictly to what is legally correct, or at least insofar as an individual justice's interpretation of law is, but the court also wants legitimacy. The Supreme Court has no cheerleaders. The Supreme Court has no public defenders. The Supreme Court has nobody that speaks out in defense of them, and they stand at odds with the executive, and they stand at odds with the legislative, right? So the Supreme Court, they'll make rulings, but they also have to be aware of, and they want to be aware of, this is why the last ruling on the Colorado ballot thing, why it was such a partisan ruling, even though they probably wanted to rule a little bit more, less in line with each other, because the leaked, or the PDF of that originally had 3 judges dissenting in part, and then they changed it to all 9 judges concurring. The court does try to keep in mind its legitimacy, and it will fight for its legitimacy in different ways. And in one of those ways is like, well, how is our ruling going to impact the United States, you know?
President or any public official to do that.
Your Honor, as this court said very persuasively in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the other court's cases.
He's trying to, I don't understand this argument. He's trying to say, like, well, you should have absolute immunity, and just if you do some bad things and that gets rid of your immunity, then, well, what the fuck is the point of the immunity? However, if I'm understanding him, then that's what he said. But the point of immunity is not supposed to be to allow you to do, obviously, bad things. What was that term? Malum in se? Malum in se? The point of immunity is not to allow you to commit obviously immoral or malicious acts. The point is to allow you some deference to commit acts which might bring you under criminal liability if you're performing the ordinary duties of your job. Good example, this would be a police officer having to kill somebody, right? Ordinarily, that's just a crime. You can't kill people. But if you're a police officer, in the course of your job or in the scope of your job, you might have to, right?
Isn't the work, though, of the improper motive, at least in the absolute immunity context, to tell us what are official acts and what are not? I mean, I'd understood that even in the first of all, your ask is absolute immunity, isn't it?
That's our principal position.
That's
yes.
your
So she's clarifying here because he's making arguments that seem to have to do with qualified immunity, but he's not asking for qualified immunity. He's asking for absolute immunity, right? So I don't think the same arguments would apply.
First of all, your ask is absolute immunity, isn't it?
That's our principal position.
That's your position is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay, so any official acts, so then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world.
Correct, because he's saying that you should have absolute immunity for all acts that are qualified acts, or I'm sorry, I shouldn't say qualified, I'm sorry, acts that count as acts in service of your job. Well, then that is the whole question then, because if I'm going to hold you criminally liable for something, I need to figure out if that act that you did was a personal one, or if that was one that a reasonable person would think was in service of your job that the immunity would apply to. That's the entire question then, that's what it becomes.
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
Yeah.
That is correct.
All right, so my question, and I think the Chief Justice may have asked this at the beginning, is
do the defendants or plaintiffs appear in front of the Supreme Court for stuff like this, or is it just their lawyers? My guess is generally it's probably just the lawyers. There's no reason for Trump to be here. He probably wouldn't have anything to contribute here. I believe for criminal matters, I think the standard for criminal courts is you always appear, that the accused himself appears, for good reason as well, because you don't want people having criminal proceedings where the person isn't even in court that's being accused of a crime or their trial is happening, right? You want them to be in the court. But I think for civil matters, I think it's usually less strict.
Correct.
All right, so my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine what, or maybe Justice Thomas, how do you determine what is an official act?
Yeah.
And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when
Everything
the
is an
president
official act.
using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess. Even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I agree. The objective, or I'm not sure I agree, but the point I would make in response to that is in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of the presidency.
All right, can I just ask you another quick question before my colleagues take it over here? At the beginning of your analysis, when you were giving your opening statement, you were talking about you suggested that the lack of immunity and the possibility of prosecution in the presidential context is like an innovation. And I understood it to be the status quo. I mean, I understood that every president from the beginning of time, essentially, has understood that there was a threat of prosecution, if for no other reason than the Constitution suggests that they can be prosecuted after impeachment.
Now, this idea that, so she's arguing, actually, presidents have always thought they could be criminally prosecuted. And I feel like I said something here, and I wasn't 100% correct because Pisco corrected me on it, and then I looked it up. Oh, no, I remember, okay. I think the justification given for this was Jack Smith had to make oral arguments in front of a court. I think it was in front of a federal court. I don't think it was the Supreme Court. Jack Smith had to make oral arguments in front of a court, and one of the arguments that Jack Smith made was, okay, fine. You guys are saying that presidents have never been indicted and can't be criminally indicted and that this would never happen. However, why is it that Nixon was given a broad pardon then by Gerald R. Ford? Wait, can I find this? Oh, there's a wiki on this. But when Ford came into office, I think he did a formal pardon of Nixon, which would have pardoned him from any criminal liability whatsoever, right? But then the question is, well, why pardon Nixon? If you can't be held criminally liable for anything, why would he pardon him? Why would he accept? Why it doesn't make any sense, right? I don't know if that's what she's going to bring up, but that was Jack Smith's arguments when he was defending the concept of there is an absolute immunity for every single act that a president does in the capacity as president.
Or the reason then the Constitution suggests that they can be prosecuted after impeachment. The Office of Legal Counsel has said forever that presidents are amenable to a threat of prosecution, and they have continued to function and do their jobs and do all the things that presidents do. So it seems to me that you are asking now for a change in what the law is related to immunity.
I would quote from what Benjamin Franklin said at the Constitutional Convention, which I think reflects best the founders' original understanding and intent here, which is at the Constitutional Convention, Benjamin Franklin said, "History provides one example only of a chief magistrate who was subject to public justice, criminal prosecution, and everybody cried out against that."
No, I understand, but since Benjamin Franklin, everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution, no?
So this is kind of like, it's funny because in some ways, I make big statements here, I could be wrong, hopefully not. In some ways, legal systems and law seems different all over the world, but in other ways, there are similarities, there are broad similarities of the legal systems that we're kind of honing in on across the world have a lot in common. And she's kind of hinting at this idea of customary law, basically, which I think is, would customary law, is that essentially like common law? When we say common law, what are we talking here? Hold on, let me check. Common law is the body of law created by judges and similar quasi-judicial tribunals by virtue of being stated in written opinions. Okay, I don't know if common law is necessarily what I'm talking here, but that basically, I believe in international law, it's called international customary law. But basically the idea is
if there's not like a written law relating to something, you're trying to figure out, well, what is the law here? You look at the actions of the actors in a particular medium, or not a medium, in a particular arena. And in some cases, all of the actors will be acting in a certain way. They'll all be saying like, well, yeah, we have to do this because we feel like we have to do this. Like, I'm pretty sure we're supposed to do this, even if there's not a written law that says it. So for international customary law is essentially this idea that like people aren't doing this just because they think it's nice or it's the right thing to do. People are doing this because they feel like they actually have to do it. And she's basically hinting at the idea, or not hinting, she's explicitly stating that, well, in the past, every president has thought this because they really did believe that this was what would happen. So that is essentially the standard that we should be going by today. And when you're arguing for an upholding of norms, you're actually arguing in contradiction to those norms, because what you're saying is, oh, well, the president can never be charged with crimes, but that's not been every other president's understanding. So she's arguing for that kind of like customary legal foundation is what it sounds like.
That they were taking this office subject to potential criminal prosecution, no?
I don't. I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon? What was up with the pardon for President Nixon?
And she brings it up. Yeah, why? So how do you answer that? I am so curious. There was a chatter that gave an answer. I wonder if Sauer's going to give the same answer. Well, the pardon was actually largely symbolic. He just, the reason why he pardoned him was just because it looked good. But but pardoning's an official thing. Why would you not just, and I believe it's the case that I think pardoning implies guilt as well. I think that when you pardon somebody, the idea is they either have already or they will essentially plead guilty and accept the pardon. But I think pardoning imparts guilt on somebody. Does pardoning mean the person was guilty? Let me check real quick on this. I don't know. A pardon is an expression of the president's forgiveness and ordinarily is granted in recognition of the applicant's acceptance of responsibility for the crime and established good conduct for a significant period of time after conviction or completion of sentence. It does not signify innocence. I think that generally for pardons, there is an acceptance of guilt there. So the idea that Nixon would have been pardoned kind of implies that a criminal conviction was at least possible, and implies that he recognized that he did do some kind of criminal act. I'm so curious what his response is to this.
What was up with the pardon for President?
Were there any actual charges when Nixon was pardoned? No, there were not.
President Nixon.
I think
that if everybody thought that presidents couldn't be prosecuted, then what was that about?
Well, he was under investigation for both private and public conduct at the time, official acts and private conduct. And I think everyone has properly understood that the president, since like President Grant's carriage riding incident, everyone has understood that the president could be prosecuted at least
Counsel, on that score,
I really wanted to hear more of a back and forth on that. Fucking Kavanaugh. All right, what does he have to say?
There does seem to be some common ground between you and your colleague on the other side, that no man's above the law, and that the president.
Oh wait, did they misidentify?
Has understood that the president could be prosecuted at least.
Counsel, on that score, there does seem to be some common ground.
Oh, sorry, I don't know why. I thought I saw him highlighted.
You and your colleague on the other side, that no man's above the law, and that the president can be prosecuted after he leaves office for his private conduct. Is that right?
We agree with that.
And then the question for his private.
I need to listen.
And that the president can be prosecuted after he leaves office for his private conduct. Is that right?
We agree with that.
And then the question becomes, as we've been exploring here today, a little bit about how to segregate private from official conduct that may or may not enjoy some immunity. And
what was the mind state of Ford when pardoning Nixon? If it was explicitly a political act, then it seems weird to invoke the legal standard. I agree. I don't know anything about. Remember, on this stream, you should have seen this by now. Okay, if you haven't learned this about me, then you are learning it. Okay, if I haven't explicitly studied it on stream, like with an interest in the topic, I don't know anything about it. I've completely fucking forgotten it. So in terms of why, I remember listening in school that they did it to heal the nation. My guess is going to be that when he pardoned Nixon, it probably also killed all those investigations as well. That'd be my guess. Why did Ford pardon Nixon? Following the release of the smoking gun tape on August 5th, 1974, Nixon's position had become untenable. In his 79 autobiography, A Time to Heal, Ford wrote about a meeting he had with White House Chief of Staff Alexander Haig before Nixon's resignation. Haig was explaining what he and Nixon's staff thought were Nixon's only options. He could try to ride out the impeachment and fight against conviction in the Senate all the way, or he could resign. His options for resigning were to delay his resignation until further along in the impeachment process to try to settle for a censure vote in Congress, or to pardon himself and then resign. Haig pardoned himself. Interesting. Okay. I don't believe that there is a pardoning that you can do from an impeachment proceeding, because that would be like the president overriding Congress. I don't believe. Hold on, let me just check real quick. Can you pardon officer of Congress? Wait. Elected officials are not officers, actually. There's something different. Can you pardon people from an impeachment? Grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Thus, the president's authority to grant clemency is limited to federal offenses and offenses prosecuted by the United States Attorney for the District of Columbia in the name. So this makes sense, right? It makes sense why the president would be able to do this, right? Because the Department of Justice and all of the federal courts exist under the executive branch, of which the president of the United States is the head of. So it makes sense that the head of that branch would theoretically be able to do almost anything with that branch, depending on how unitary executive bullshit, whatever the fuck, right? Depending on your theory of the president's powers, right? So it would make sense that the president himself could pardon you, theoretically, as he's the god emperor of the federal courts. But for things that Congress does, in terms of impeachment, which I believe is a congressional thing, and then obviously there's like state impeachments and other things, but like the president himself shouldn't be able to pardon somebody from impeachment. So to pardon himself implies that he thought his government, his own branch, the DOJ, was going to come after him with federal charges, right? Haig told Ford that some of Nixon's staff suggested that Nixon could agree to resign in return for an agreement that Ford would pardon him. On this subject, Ford wrote, Haig emphasized that these weren't his suggestions. He didn't identify the staff members, and he made it very clear that he wasn't recommending any one option over another. What he wanted to know was whether or not my overall assessment of the situation agreed with his, emphasis on original. Next, he asked if I had any suggestions as to courses of action for the president. I didn't think it would be proper for me to make any recommendations at all, and I told him so. This is Ford writing. In a Washington Post story published the night Ford died, journalist Bob Woodward said that Ford once told Woodward he decided to pardon Nixon for other reasons, primarily the friendship that Ford and Nixon shared. Following Nixon's resignation on August 9, 1974, the Nixons flew to their home, La Casa Pacifica, in San Clemente, I don't know how to pronounce it in English, San Clemente in California? I don't fucking know. According to his biographer, Jonathan Aitken, after his resignation, Nixon was a soul in torment. Congress had funded Nixon's transition costs, including some salary expenses, but reduced the appropriation from $850,000 to $200,000. With some of his staff still with him, Nixon was at his desk by 7 a.m. with little to do. Nixon's resignation had not put an end to the desire among many to see him punished. With his resignation, Congress dropped its impeachment proceedings against him, but criminal prosecution was still a possibility both on the federal and state level. That's kind of instructive for Trump, right? The Ford White House considered a pardon of Nixon, but it would be unpopular to the country. Nixon, contacted by Ford emissaries, was initially reluctant to accept the pardon, but then agreed to do so. So a pardon has to be accepted, I think, right here, which implies guilt or an admission of guilt, right, to criminal charges. Or potential criminal charges. Ford, however, insisted on a statement of contrition. Nixon felt he had not committed any crimes and should not have to issue such a document. Ford eventually agreed, and on September 8, 1974, he granted Nixon a full, free, and absolute pardon that ended any possibility of an indictment. Nixon then released a statement. I was wrong in not acting more decisively and more forthrightly in dealing with Watergate, particularly when it reached the stage of judicial proceedings and grew from political scandal into a national tragedy. No words can describe the depth of my regret and pain at the anguish my mistakes over Watergate have caused the nation and the presidency, a nation I so deeply love and an institution I so greatly respect. I feel like the Nixon stuff is going to be pretty relevant to this, but who knows? We'll see. Does the Supreme Court not have to do everything in their power to make sure Trump is on the ballot come election time, since they use the political temperature of the country as a reason for the 14th Amendment decision? So they probably should say he's immune using the same reasoning, no? The immunity one is a much bigger thing. That's why I feel like they might just kick, and they're all asking questions about figuring out what an official act is. They might just kick it back to the lower courts here. But we're in an unprecedented time. It is really scary. Like if Trump wins, the election, we're in such a weird spot. We're in a very, very weird spot legally. Nobody knows what will happen from that point. Tyler from Earth, thanks for the 5 gifted subs.
I'm sure we're going to spend.
Why does it necessarily mean guilt? It says the opposite as well. It doesn't confer innocence. Hold on. Just to be very clear, in the American legal system, a lot of people don't understand this. Guilt is not the opposite of innocence, and courts generally don't get in the business of determining whether or not a party is innocent. You're charged with a crime, and then you're either convicted of that crime or you're acquitted of the charges. If you're acquitted of the charges of a crime, what that means is that the prosecutor, the state or the government, the federal government, couldn't make an argument that the jury felt was beyond a reasonable doubt that the accused had committed whatever they had been charged of. Courts do not find people innocent. They only acquit you of charges because they feel like the state or the government didn't prove beyond a reasonable doubt that the accused committed those crimes, what they were charged of. That's a very, very important distinction. Remember that. Innocent and guilty are not the opposite. Oh, he's not guilty, he must be innocent. That's not true, right? They don't say he's innocent, they say not guilty. It's very, very, very important to keep that in mind.
That may hear today a little bit about how to segregate private from official conduct.
That is not an answer to the question. I don't know how else to answer the pardon thing. Pardon seems to imply guilt. You pardon people for crimes they were convicted of, or you can give pardons in anticipation of a crime that they were convicted of. But a pardon seems to be, that's what I've read. If you have something different that you want to link me, go for it. But I've never read, we Googled a little bit earlier, I've never read anything that a pardon implies that they're innocent, or a pardon, it seems that a pardon necessitates some aspect of guilt, or we're committing a crime.
That may or
exactly, but he had no charges? No, but he had investigations that were potentially leading to charges.
Today a little bit about how to segregate private from official conduct that may or may not enjoy some immunity. And I'm sure we're going to spend a lot of time exploring that. But the D.C. Circuit in Blazing Game, Chief Judge there, joined by the panel, expressed some views about how to segregate private conduct for which no man is above the law from official acts. Do you have any thoughts about the test that they came up with there?
Yes,
Do you understand that the federal courts are not under the executive branch of government, right? Wait, no, yeah, you're right. They're under the judicial branch of government. Wait, did I say the opposite? Hold on. The DOJ and the investigators, hold on, you're right. And I think I know what I said earlier. You're right. The courts are not under the courts themselves. Well, the judges from the courts are part of the judicial. They get nominated from the executive, but they exist separately. But in federal courts, the people bringing cases are under the executive. Sorry, I'll get more clear. So the prosecutors in these courts are going to be all part of the executive branch, right? I understand, if that's my understanding. But if the executive wants to kill a case, they can kill the case in any court because they're the people that are bringing the case in front of the court, right? Does that make sense? Yeah. Destiny, pardons need not follow convictions, but can be issued before or during a criminal prosecution. Is that what you're saying? I think you can preemptively issue a pardon, and the idea is if the person accepts it, they're kind of accepting responsibility for whatever it is they've done. That's my understanding. But I don't know if there's strong legal ground on that. That's just what I've read, and that's what I Googled, and it seemed to say that.
We think in the main that test, especially if it's understood through the lens of Judge Katsas' separate opinion, is a very persuasive test. It would be a great source for this court to rely on in drawing this line. And it emphasizes the breadth of that test. It talks about how actions that are, plausibly connected to the president's official duties are official acts. And it also emphasizes that if it's a close case or it appears
plausibly connected to that. So he's saying that if it seems like it might be connected to a presidential duty, then it probably is. And I think he's about to say, it sounds like he's about to say, if you're on the edge, then yeah, you would just assume that it is a presidential duty. It sounds like what he's about to argue.
Duties are official acts. And it also emphasizes that if it's a close case or it appears there's considerations on the other side, that also should be treated as immune. Those are the aspects of that we'd emphasize as potentially guiding the court's
discretion. And that left open, in that case, the possibility of
assassinating
further proceedings and trial.
Okay.
Exactly right. And that would be a very natural course for this court to take in this place. The court can and should reverse the categorical holding of the D.C. Circuit that there's no such thing as official acts, especially when it comes to...
But you'd agree further proceedings would be required.
That is correct. There would have to be, and I would point the court to Anderson against Creighton, where the court said there'd be kind of two stages to these further proceedings. There's looking at the indictment itself, or in that case it was a complaint, but look at the charging document itself and see whether on the face of it this is alleging official acts. And if if not, or it can't be determined, then there'd be a factual proceeding. And all that under Mitchell against Forsyth and so forth would have to occur before any other proceedings in the district.
Mr. Sauer, go ahead. Mr. Sauer, you began.
God, how nice would it be to have these arguments in person so that when people are like cutting each other off, there's not like a fucking, there's not like delay or anything on Discord.
The district.
Mr. Sauer, go ahead. Mr. Sauer, you began by explaining why you believe that immunity from criminal prosecution is essential for the proper functioning of the presidency. But my question is whether the very robust form of immunity that you're advocating is really necessary in order to achieve that result. So just to take one possible alternative, suppose the rule were that a former president cannot be prosecuted for official acts unless no plausible justification could be imagined for what the president did, taking into account history and legal precedent and the information that was provided to the president at the time when the act was taken. Would that be sufficient, or if it is insufficient, why would it be insufficient?
Why aren't conservatives against Trump winning this decision? It would be a massive expansion of executive power. Nobody cares about any of that shit. It just depends on if it supports their guy or not. Nobody has any principles regarding any of this shit. Sorry if it's a dumb question, but are the justices in the court highly qualified in their field, or is this knowledge the standard for a judge with 20 plus years of experience? I think most judges are going to be pretty qualified, but the level of knowledge that a judge is going to have is going to depend upon how high or low in a court a particular judge is. So like if you go to like an individual city and there's like a judge that sits in like the lowest of the low courts, like they're still going to be very knowledgeable about matters of the law, but they might not know expansively as much law. But the higher the court you go, generally the wider the region it is that you're making rulings about, and the more cases you're hearing, the more broad level of legal knowledge you're going to need. And then when it comes to federal judges, my understanding is that federal judges are quite knowledgeable on a lot of stuff, that federal judges are very qualified and know a lot about the law and will know a lot about of different particular cases, not just Supreme Court ones, but all sorts of cases that they draw legal knowledge from. And they also have staffers and clerks, whether it be clerks, just staffers, I don't know what you call them, but the people underneath them will help them with legal research as well, right? Like a justice, not even a Supreme Court justice, but a lower, like a federal judge might say something like, oh, like I need you to bring up every single case. Like if you do law school and you intern, you might intern for a court where they ask you to do this type of legal research. Like, hey, I need you to bring up every single case that had to do with Terry stops in the 1980s for this state, because we're a state judge, we're making, I need you to bring up all the cases, and then their staffers or their court personnel or whatever might be involved in bringing that up, and then the judge will review it all and everything. Yeah. What did Trump even do? I'm so confused. Well, one of the things, I believe that this has to do with if Trump wins on this case, then this saves Trump from, I believe, the federal case having to do with January 6th. I don't think that this would help him versus the Mar-a-Lago documents case, and I don't think it would necessarily help with either of the two state cases, although maybe it would impact the Georgia RICO one, because the Georgia RICO one seems to be structured after the Jack Smith federal one relating to the January 6th stuff, although I don't know if it would help with the Georgia one either, but at the very least it would save him from Jack Smith's federal one about January 6th. Because all of the actions that he took during the January 6th stuff that he's being indicted for, they would argue that, well, he was acting as president during those times, so I don't think that this immunity would help him for the Mar-a-Lago case, because that's after he was president. It might help him for the Georgia RICO case. I don't know how this immunity would help with the state level, though. I don't know if that gives you state level immunity. But for the Jack Smith election fraud case, for this set of indictments, the ones having to do with January 6th, the conspiracy to defraud the United States, to obstruct an official proceeding, and the conspiracy against rights, I think it would basically nullify this entire federal case. What odds would you say that Trump ends up serving jail time? I have no idea. I feel pretty confident he's getting convicted of something. Maybe, unless these like federal courts save him somehow, or he gets blazing game versus Trump. Oh, they're just referencing what this case is that went to the Supreme Court. I'm sorry. Okay.
The U.S. District Court for the District of Columbia considered whether former President Donald Trump is entitled to absolute presidential immunity from damages liability for allegedly inciting a riot at the U.S. Capitol. When you read this, though, be careful. Remember, for the Jack Smith stuff, he's not actually being accused of incitement. That's not one of the 4 charges that he's facing, or one of the 4 indictments he has for that. One of the 4 charges he's facing for that indictment, I should say. Although it would probably cover that as well.
But determination. The reason I think of Blazingame is because it talks about an objective, context-specific determination to winnow out what's official and what is purely private conduct. And again, with a strong degree of deference to what
I'm sorry. If I understood Justice Alito, he's suggesting not that. He's suggesting whether, even if it is an official act, whether you still grant immunity if that act is not plausibly viewed as within the realm of law. He can correct me if I'm wrong.
That was the question.
That, I think, would be a superior rule than the categorical denial that emerged in the trial court here. I do think it would
I'm not quite sure why he used the word plausible, because that seems to negate
the immunity, or
might as well give absolute if you're saying plausible, because anybody could argue plausibility.
And
we don't even require
because remember, plausibility is a very, very low standard. We know that from the ICJ case when they said it was plausible that Israel's committing a genocide. All across the world, plausible is recognized as quite a low standard. It's like a step above, I think prima facie. It's just are the facts here? Do they seem like maybe true? Okay, you hit the plausibility standard essentially.
Because anybody could argue plausibility. We don't even require plausible. We require reasonable in qualified immunity. So
reasonable is a higher standard than plausible.
Well, I mean, one might argue that it isn't plausible.
Are both sides accepting that Trump incited a riot? Whether or not Trump incited a riot is a fundamentally different question, and it's one that Jack Smith isn't taking up, which is probably good because incitement to riot is going to be a very, very, very hairy case to sort through, and the precedent there is incredibly scary because when you're talking about him inciting a riot, now we're getting into very dangerous and very challenging questions of freedom of speech. What counts as a politician for inciting a riot? So smartly, I think it was smart, Jack Smith completely left that off of the charging documents. He's not looking for incitement of a riot. That's not what he's charging for. So that's not a question that's going to be asked or have to be answered or addressed by any of the courts. I don't even know if the courts would want to rule on that because that's such an unbelievably hairy First Amendment question.
I don't want to slander SEAL Team 6 because they're honorable. They're honorable officers, and they are bound by the Uniform Code of Military Justice not to obey unlawful orders. But no, I think one could say that it's not plausible that is legal, that action would be legal. And I'm sure I've thought of lots of hypotheticals. I'm sure you've thought of lots of hypotheticals where a president could say, I'm using an official power, and yet the president uses it in an absolutely outrageous manner.
That, if we're an objective determination, may well be an interesting approach to take.
So apply it to the allegations here.
Yeah.
What is plausible about the president assisting in creating a fraudulent slate of electoral candidates?
Because this has to do, that fraudulent electorate slate, this has to do with the with what the Jack Smith case is about. Not with incitement. So the electorate, you can't search? What, is this uploaded as a fucking picture? It is a picture. Yes! Part of the, so if you read the indictment under here, you've got the defendant and co-conspirators organized fraudulent slates of electors in 7 targeted states, of which I think Arizona or some state just came out with a new set of indictments for Trump today over this. Indictments, Trump. An Arizona grand jury indicted 18 people Wednesday in the ongoing investigation into an alleged attempt to use alternate electors after the 2020 presidential election as part of a wider alleged conspiracy to falsely declare. I believe that Donald Trump, people think that he's an unindicted co-conspirator in this. I think that's what I read. Or no, an indicted co-conspirator, not an unindicted co-conspirator. Am I wrong on this? Does anybody know?
an unnamed indicted co-conspirator. I think, but I could be wrong on that. He might not be indicted in this at all, or he might not be unnamed at all. I'm not sure. The fact that I'm not seeing things pop up immediately saying that makes me think that he's probably not then, because I think that would be, people would be, in these headlines, it would say this. While Trump is not among those charged in Arizona, the details in the indictment suggest he is unindicted co-conspirator 1. Oh, okay, so he is a co-conspirator, but he's unindicted. I'm not sure why they chose not to indict him, but okay. What's the point of being unindicted? I don't know. It might just be in the facts of the case that you're saying that this is a person that helped further this crime, but you don't think you've got the evidence to charge them formally with a crime? Maybe. I'm not 100% sure why you would have an unindicted co-conspirator. The point I'm making is why the defense asking for immunity from incitement, regardless if it's granted, does that not imply that Trump in fact incited a riot? Well, I think it's because the case that ended up going to court seems to be this Blazing Game case. Blazing Game case. I don't know anything about this particular case, though. I only know about all the big indictments, but this seems to be the one that moved to the Supreme Court. In Blazing Game v. Trump, the U.S. District Court for the District of Columbia considered whether former President Donald Trump is entitled to absolute presidential immunity from damages liability for allegedly inciting a riot at the U.S. Capitol. Case summary. On January 6, 2021, a crowd of supporters from Trump allegedly incited this action by, among other things, encouraging attendance. The plaintiffs in this case, U.S. Capitol Police officers James Blazing Game and Sidney Hemby, sued Trump for damages for the harm these actions caused them. Among other things, the officers allege that Trump's unlawful conduct caused them to suffer both physical and emotional injuries. Trump filed a motion to dismiss, arguing in part that he is entitled to absolute presidential immunity and therefore cannot be held liable for the events on and leading up to January 6th. The CAC... I don't know what that is. Constitutional Accountability Center, maybe? I don't know. Filed an amici curiae brief in the D.C. District Court in support of the plaintiffs on behalf of law professors who are experts in constitutional law, executive immunity, and separation of powers principles. Our brief argued that Trump is not entitled to absolute presidential immunity. Okay, so basically, there's a civil case that's being brought in a district court, in the D.C. court, I think. Wait. Sorry, it's in a D.C. federal court. And the plaintiffs are saying, hey, we want to sue this guy because, we got fucked because of a riot that he caused. And part of Trump's counter argument is, actually, I've got absolute immunity, so suck my dick. Now, the absolute immunity question is essentially what's caused this, I think, to climb the courts up to the Supreme Court now. And the Supreme Court's answer on the absolute immunity thing here is probably going to be instructive in other court cases relating to Donald Trump. Oof, okay. 3 judges nominated from Trump himself into the Supreme Court. How could they be bias-free judges? That's how our judicial system works. That's part of the reason why we have life terms for Supreme Court justices. The idea is, just because Trump put them on the Supreme Court doesn't mean they have to do anything politically to remain there. These are lifetime terms that you serve on the Supreme Court. So ideally, they're shielded from a lot of that political pressure because they're there no matter what. Trump can't punish them. I don't even know if it's possible to... Can you impeach a Supreme Court justice? You might be able to with like supermajorities or something. That the justices hold office as long as they choose and can only be removed from office by impeachment. Has a justice ever been impeached? The only justice to be impeached was Associate Justice Samuel Chase in 1805. So they can be impeached by... They could be impeached, I think, by Congress. 2/3 vote in the Senate, but this has like never happened, basically. Or maybe one time, but yeah.
A fraudulent slate of electoral candidates.
Okay, anyway, sorry, it took us longer to get here. Now I'm interested. So how does Sauer, so we've gotten all the legal theory out of the way. Well, these are the type, like maybe official actions, shouldn't allow you to be convicted or charged with a crime, but like maybe there are personal actions that could be. And well, now we've talked a lot, but what does a personal action look like? What does an official action look like? And now Sotomayor is finally saying, okay, let's get into the specific charges here on the Jack Smith case, right? How do you tell if this is a personal action or not? So Sauer's answer is going to be very interesting, I think.
A fraudulent slate of electoral candidates. Assuming you accept the facts of the complaint on their face, is that plausible that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cited in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those 2 cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment or even...
Knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He
This isn't, I think the example he's giving is not the equivalent at all here.
knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to address a more
Ooh, that I don't agree with his characterization of the indictments here. These indictments do specifically say that it doesn't matter what had arisen from those states as genuine electors. It does use fraudulent slates of electors, and it does use very clear language here, attempting to mimic the procedures and the legitimate electors were supposed to follow under the Constitution and other federal and state laws. This included causing the fraudulent electors to meet on the day appointed by federal law, on which legitimate electors were to gather and cast their votes, cast fraudulent votes for the defendant, and sign certificates falsely representing that they were legitimate electors. There's a lot of accusations of fraud in here. I think her characterization was quite accurate. His characterization is completely incorrect, but interesting that he says that.
mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to address a more higher level point, a fundamental point, which is that, as Justice Alito's question indicated, there's a whole series of structural checks other than criminal prosecution that are designed to deter these kind of, outlandish scenarios or extraordinarily obviously illegal things.
And he's going to say he's just going to appeal to the impeachment thing. If you don't like it, just impeach the guy. But what if they're out of office? Or what if they're about to leave office? Is impeachment really the only answer?
And that's been viewed in this court's opinions going all the way back to at least Martin
Where
against
do you
Mott.
think the D.C. Circuit went wrong in how it determined what was official versus what's personal?
Well, I read the opinion below in this particular case as adopting a categorical view. It does not matter is the logic of their opinion, because there is no immunity for official acts, and therefore, that's the end of the story. I don't really think they went wrong in Blasingame in the civil context when they engage in the same determination with respect to what's official and what isn't official. There, we agree with most of what that opinion says.
And for some official acts that are not within the Article II exclusive power, okay, so official acts but not within the Article II exclusive power.
Hold on. So to be clear, somebody said you can impeach a president that's left office. There's no reason why Congress can't impeach Trump today. That wasn't the view of Republicans in the Senate. The view of the Republicans in the Senate was, no, actually, you can't impeach somebody who's already left office. That doesn't make sense. So it seems to be, this feels like an unanswered question. I don't know if there's actually, even my limited legal knowledge, I think you can't impeach somebody who's out of office, because I believe the only remedy offered by impeachment, by way of impeachment, the only remedy, meaning the only cure or way to resolve an injury or damage or something that's caused, the only remedy is removal from office. So why would you impeach somebody who's not in office? It doesn't make any sense. If impeachment only provides a way by which you can remove somebody from office, if they're not in office anymore, it wouldn't make sense to impeach them, I believe. They can't run for office again. Is that true? Does impeachment prevent you from running for future office? The Constitution requires a 2/3 vote of the Senate to convict, and the penalty for an impeached official upon conviction is removal from office. In some cases, the Senate has also disqualified such officials from holding public offices in the future. There is no appeal. In some cases. So it doesn't sound like this is a rule. Wasn't that Pelosi's argument to bar him from office? Maybe that was. Maybe for presidents it is. I'm not sure. They vote on it? Oh, maybe it's a vote after impeachment? Okay, so, but then even so, then your only two remedies are you remove somebody from office and you prevent them from holding future office. But it doesn't give you, there's no criminal or civil proceedings past that, right?
Even for those, I assume you would think that a clear...
The Constitution says a president impeached and convicted, they are barred from all offices. Wait, can you link that? Where is that? Impeachment clause, Constitution. It'd be nice to just read that in the... The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 1, Section 2, Clause 5. The House of Representatives shall choose, nice one, their Speaker and their other officers, and shall have the sole power of impeachment. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Judgment in cases of impeachment, seriously, shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. The president, vice president shall be removed. Conviction. Okay. Shall not extend further than to remove from office and disqualification to hold and enjoy any office of honor. Is this automatic, or do they vote on this separately? I'm not actually sure. I don't know the answer to this. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. This makes it sound like then if you're convicted in an impeachment proceeding, then you can face criminal things after the impeachment conviction. I don't know. I don't know if there's like solid answers on any of this, but
that there were sufficient private acts in the indictment for the case to go back and the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney, was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results.
When she says special counsel and petitioner, is she talking about Jack Smith? Is he considered like special counsel for the U.S.? She's talking. I think she's referring to Jack Smith's documents here relating to another case. I believe is who she's referring to. I believe.
He was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged, I mean, we dispute the allegation, but
Of course.
sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That
Private.
also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private. I don't want to.
So that's interesting that Sauer is arguing for a very broad immunity here for presidential actions. But it's interesting to me, or maybe this has been the whole case, I just haven't followed this closely, that he's basically conceding that all of the charges relating to the Jack Smith case would be private actions, so they don't apply here. So earlier I said the reason why this is important is because it seems like it would nullify that case, but it seems to be that he's saying that it would nullify that case at all because those are private actions, not the public ones that he's arguing in favor of immunity for. Which makes me wonder, why the fuck are they even fighting this in the Supreme Court? Unless he thought that there'd be huge civil liability for the incitement to riot stuff. I guess why wouldn't you fight on everything, huh?
Thank you, counsel. And what is the consequence in terms of going forward with your acknowledgement that those are private acts as opposed to official acts?
If you look at the indictment here, there's a bunch of acts that we think are just clearly official. There may be allegations that mostly relate to what the government has described here as private aim or private end, and the court should remand or address itself, but remand for a Brewster-like determination, which is what's official and what's private. The official stuff has to be expunged completely from the indictment before the case can go forward, and there has to be a determination, at least on remand, of what's official, a 2-stage determination of what's official and what's private.
Well, if you expunge the official part from the indictment, how do you, I mean, that's like a one-legged stool, right? I mean, giving somebody money isn't bribery unless you get something in exchange. And if what you get in exchange is to become the ambassador to a particular country.
He's bringing up the weird thing earlier where it sounded like Sauer was saying like, okay, well, you can't talk about the official acts that they do, but you can still charge them for the crime. But then the question was like, okay, well, if I take a bribe to appoint somebody and then you can't talk about the appointment, then I just get money. What's the crime there?
Mr. Sauer, in assessing the official acts of a president, do you differentiate between the president acting as president and the president acting as candidate?
Yes, we do, and we don't dispute, essentially, the blazing game discussion of that.
Okay.
But of course, that has to be done by objective determinations, not by looking at what was the purpose of what you did this. And that's the most important point there.
Did you, in this litigation, challenge the appointment of special counsel?
Not directly. We have done so in the Southern District of Florida case, and we totally agree with the analysis provided by Attorney General Meese and Attorney General Mukasey. And it points to a very important issue here, because one of their arguments is, of course, that we should have this presumption of regularity. That runs into the reality that we have here an extraordinary prosecutorial power being exercised by someone who was never nominated by the president or confirmed by the Senate.
If you apply for immunity, does that imply that you're guilty? It can imply that you're guilty on like a layman's level. You might look at somebody funny for it, but I mean, legally, not necessarily, no. Yeah, immunity just means that, this act can't come under consideration for criminal prosecution. It doesn't necessarily say that you're guilty of anything. It just says you can't even consider whether I'm guilty. But obviously, people are going to look at you like, the fuck? We are watching the Supreme Court use the same tech as Jizdical to tell us who is talking Pepe Mas.
Evidence of those official acts were precluded at trial. So is that what you're saying, that the prosecution should not be permitted at trial to prove the official acts as part of the conspiracies that are alleged?
Absolutely, and we think that's just the clear implications of Brewster and Johnson. And
Oh, okay. So if I'm understanding this more, the reason why he's okay saying that all those other Trump acts were private is because if it goes to court, it wasn't Alito, was it Roberts that said that, like, okay, well, now your charging document is like a one-legged stool. Let's say that I've got a president. So interesting. So Sauer is saying, like, listen, yeah, we think that if you want to charge somebody for taking bribes, that's a private action. Yeah, and if somebody took 10 bribes for 10 appointments, yeah, that's a private action. Go ahead and take them to court for it. But Sauer is saying, but hold on. If you're going to take him to court for doing 10 bribes, you can't talk about things that he did in his official capacity as president. He appointed 10 people. He's got the right to appoint those 10 people. The bribes are a separate matter. And then the questioning from the judges is like, okay, wait, well, hold on. How the fuck are we supposed to charge you for a crime if we can't talk about, the prosecution can't even bring up your acts as in the official capacity as president? Like, we've only got, I think like Robert said, a one-legged stool. How the fuck do we even charge this then? That's what it sounds like. Is it safe to say that this might be one of the most important Supreme Court decisions in the history of the country? I mean, I would say not that important because presidents ordinarily aren't doing crimes. But, I mean, obviously in relation to Trump, I think this is probably fairly important, yeah.
Be permitted at trial to prove the official acts as part of the conspiracies that are alleged?
Absolutely, and we think that's just the clear implications of Brewster and Johnson and their discussion in a very analogous context.
Thank you.
Justice Sotomayor?
I'm a little bit confused by that.
Yeah. How do you do this? So
if you have a scheme to defraud,
then you have to have the official act and the criminal part, but they're both of them are together. The fraudulent part incorporates or is incorporated by, I don't know, you say the official act. How could you possibly separate these two things?
if you have a scheme to defraud or a scheme to accept bribery, there's evidence from which you can infer that scheme, and one of it is that the appointment actually happened.
Yes.
It's an official act. You wouldn't expunge that as evidence.
Yeah.
You would instruct the jury that there's no liability for the actual appointment, that the liability is
for the bribe.
accepting the bribe. Similarly here, I don't think the indictment is charging that the obstruction occurred solely because of conversations with the Justice Department. They're saying you look at all of the private acts and you look in the context of some of the public acts and you can infer.
I think the best thing I can say to that is, and I think this ties into the Chief Justice's question about a one-legged stool. Brewster and Johnson in subsequent cases like Heltowski versus Meaner essentially say that this is a one-legged stool problem. It will be difficult for some of these prosecutions to proceed, and that is the implications of official immunity.
Okay, gotcha. Yeah. Okay. So he's saying right away. So I was curious, like, well, why would Sauer try so hard to fight these if it's not even saving him from the other cases? But it will save him from the other cases because they're going to say you can't bring up any of the official acts. So if you want to say that Trump did some fraudulent shit with like the elector stuff, that's fine. But you can't bring up anything about the elector stuff. You've got to try to find another way to talk about it, which is obviously impossible, right?
Which is dictated in the Constitution here by the Executive Vesting Clause.
Predictions about the case. Do you think they will grant immunity? Do you think the election will finish before the case starts? I have no idea. I'm only 31 minutes through oral arguments. We'll see.
Justice Kagan?
Can I continue on in Justice Barrett's vein a little?
Wait, do you think Sauer honestly believes the validity of his own arguments here? I don't know. Doesn't matter. It's not up to us to assess whether he believes in the validity of his arguments. It's up to us to assess the arguments themselves. That's what the Supreme Court's doing. And that's what we should do, yeah.
And one of the states changed the results in the defendant's favor.
We have taken the position that that is official.
Oof.
That's official?
Yeah.
Yes.
Why would that be official?
Because they can organize slates of electors. Why wouldn't they be able to, right? This is his argument. But this is wild, yeah. Or it seems like a dumb argument, I guess, is what I'm saying.
Because the organization of alternate slates of electors
is part of the
based on, for example, the historical example of President Grant is something that was done pursuant to and ancillary and preparatory to the exercise of the core recommendation clause power. So when President Trump
couldn't he have taken this action just in the status of a candidate?
The fact that he could have done so doesn't demonstrate that he did do so in this case. And based on the allegations, we think it's clear he did not, that this was done in an official capacity.
Really? That it was the official capacity as president to ensure that electorate slates were done up in a certain way to guarantee the winning of the election? That was more a presidential action than a candidatorial action? Interesting. By interesting, I mean retarded.
The defendant asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to communicate with state officials and urge them to view what he views as their job under state law and federal law. That's an official act.
That's wild. So like so he's going with. So I want to hear the assassination question again, because now it feels like we're essentially saying everything can be an official act as a president. Basically, any possible thing you can do could really be an official act. Yeah.
That's an official act.
Well, attempting to defend the integrity of the election, I mean, that's the defense. The allegation is that he was attempting to overthrow an election.
Essentially, exactly right. And neither allegation of what the purpose is should make a difference as to whether it's immune. That is.
Oof. Well, to be fair, Obama assassinated an American citizen, didn't he? Yeah, but it was clearly under the purview of his job as president, and to draw like an individual benefit there or something. I mean, unless like you had like evidence that this guy, fucked Michelle or something, I don't know how you could possibly make that comparison in good faith. It's a totally different thing.
It is extremely strong precedent from this court.
Does it strike you as odd that your understanding of immunity goes way beyond what OLC has ever claimed for a former president?
I view the OLC opinions here as strongly supporting us, because any time a congressional statute basically got anywhere near touching the president's prerogatives, they've said, we're going to interpret the statute narrowly to avoid that.
So well, that's a different question. I mean, what OLC has...
Also, let me just do a little bit of progressive circle jerking. How cool is this? It's a monumental Supreme Court decision that's being decided by our highest court. And look, you've got 2 black people, you've got 4 women. Look at the composition of this court. How cool is that? Wow. I'm not going to try to guess ethnicities, but that's a cool thing.
Has always said is that sitting presidents get immunity, but former presidents, no. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president. But that's a very different argument than the immunity claim that you're making here, which OLC has definitively not supported.
I don't know if I put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty.
One thing I will say is that if the Supreme Court were to make a broad ruling on this and were to appeal to those original statements, I would be incredibly ass-pained, given how much and how keen they were to completely throw out every historical statement relating to the 14th Amendment in favor of like keeping the country cohesive and together. That would be very funny if they completely 180'd on that. It's like, actually, you know what? Based on these statements in 1812, we think that the president actually enjoys super immunity from every single potential charge. I don't think they'll rule that broadly. That would be wild, but...
That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the blazing game analysis or even the Fitzgerald analysis that we've been talking about.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act.
But plainly unlawful? I mean, he's the chief executive. He's the commander-in-chief of the armed forces, right? It's a hard one.
If one adopted Justice Alito's test, that would fall outside. Now, if
you're expecting every single individual soldier to apply that standard and be able to arrive at the correct answer, there's no criminal liability here for the president whatsoever.
Adopts, for example, the Fitzgerald test that we advanced, that may well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize...
Okay, I hope they ask, because he keeps saying, well, he's got to be impeached and convicted in the Senate first. What if he's already out of office, though? Can you impeach... I don't think we've asked that question yet, right? Can you impeach and convict somebody after they've been after they're out of office? I wonder if that comes up at all.
Well, he's gone. Let's say this president who ordered the military to stage a coup.
Okay, thank you. He's out of office.
He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief.
Yep.
He
military.
Talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand because the framers...
But we already got... But what if he's out of office? Ask again. Kagan, don't let him dodge this. Ask him again.
That kind of...
If it's an official act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific...
Okay, but ask if he left office already, though. Oh, we were on it, and then we got off it.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And that is the wisdom of the framers. What they viewed as the risk that needed to be guarded against was not the notion that the president might escape, a criminal prosecution for something, sort of very, very unlikely in these unlikely scenarios. They viewed much more likely and much more destructive to the republic the risk of factional strife discussed by George Washington.
The framers did not put an immunity clause into the Constitution.
Correct. Yeah, that you're reading a lot into that. And they've already given historically the idea that presidents, especially the Nixon example, thought that they could be criminally prosecuted. As a dumb gish gallop. Don't want to go back to that argument. I want to hear the one, but if the president is out of office, how do we hold him accountable then for actions that he did in office? I really, really hope that they go back to, that question. Destiny, this attorney seems very capable given what he's arguing. I would hope so. As an attorney you're sending to the Supreme Court better be fucking capable. You're not sending fucking Giuliani out here, right?
They knew how to. There were immunity clauses in some state constitutions.
Yep.
They knew how to give legislative immunity.
Yep.
They didn't provide immunity to the president. And, not so surprising, they were reacting against a monarch who claimed to be above the law.
Yep.
Wasn't the whole point that the president was not
an ordinary
a monarch,
citizen,
and the president was not supposed to be above the law?
Correct.
I would say two things in response to that. Immunity, they did put an immunity clause in a sense. They put in the executive vesting clause, which was originally understood to adopt a broad immunity principle that said...
Did it? Was it? Broad immunity? From where? I think you have to cite or source something where that was understood to also confer broad immunity from criminal prosecution. I think you have to point to something there, because I feel like the examples that were pointed out earlier by... I don't remember if it was Jackson or who else pointed out earlier, it seemed like nobody's operating under this assumption, especially with the Ford-Nixon thing.
Set forth in the very broad language of Marbury against Madison. And also they did discuss and consider...
I'm also curious, in Marbury v. Madison, I don't even know the details of that case. I don't know anything about it other than that's where judicial review came from. Did this... I don't know enough about what this said or would have said about immunity or implied immunity or any... I don't know enough. I don't know any of the details of that case. I'm confused by this argument. Let's say that Trump actually perpetrated one of the school shootings that happened while he was in office, but the evidence of that was only discovered after he left office. Does his argument mean he can't be charged because it wasn't impeached? Yeah, that's what I'm curious about. That's what I hope that they go back to, because Kagan started asking about that, but then he switched topics here.
What would be the checks on the presidency? And they did not say, oh, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says we don't have that. That's not.
Well, hold on. Criminal prosecution isn't supposed to be a check on the presidency. It's supposed to be a way to hold a citizen account for a criminal act. It's not supposed. Nobody here is talking about this serving as a check on the presidency.
And consider what would be the checks on the presidency. And they did not say, oh, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says we don't have that. That's not an option. Everybody cried out against that as unconstitutional. The structural check we're adopting is impeachment. And it's very clear on that in pages 64 to 69 of the second volume of Farrant.
Thank you.
Why'd you say thank you? Ask him more. We're not talking about impeachment or whether you can impeach somebody. It's the question of like the criminal liability here, right? Impeaching somebody and convicting in the Senate that's not a criminal proceeding. There are no criminal convictions for that.
Justice Gorsuch?
Just returning to the Chief Justice's hypothetical about the ambassador sale and bribery. Congress has a statute that specifically names the president and says he can be criminally prosecuted for bribery, presumably after he leaves office.
Congress has a statute. What is that? Congress statute, or what would be congressional statute, president, statute, president, bribery, convicted. He's not just talking about the impeachment thing, right? Or is he? Maybe he'll get more. We'll just let him talk.
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they're engaged in drone strike, all the hypotheticals? I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
That is, didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative. What we think is most important.
We've never answered whether a president can do that. Happily, it's never been presented to us.
And if the doctrine of immunity remains in place, that's likely to remain the case for those very issues. As Fitzgerald, I think, very powerfully emphasized, the real concern here is there going to be bold and fearless action? Is the president going to have to make a controversial decision where his political opponents are going to come after him the minute he leaves office? Is that going to unduly deter? Is that going to dampen the ardor of that president to do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy?
What is I'm so curious what, I wish they would say, can you give an example of some of that bold and fearless action that you think might be curtailed in the future? Because what Trump has done here is not bold or fearless. None of the parts of these federal indictments are bold and fearless action by Trump in service of his job as the president and working on behalf of the American people. There are things in service to himself. There are things to personally entrench him into the powers of the presidency. I'm so curious. I doubt I'll ask. I'm curious what an example of some of these would be.
So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase.
Plain reading, interesting. So I don't know if this has been tested before, but some people, I guess, are reading this. So Article 1, Section 3. Let's get this. Oh, no, Article 1, Section 3, Constitution. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. So this is just saying that if the House is impeached, it goes to the Senate. The Chief Justice of the Supreme Court sits as the presiding over the court, basically, and then 2/3 of vote will vote to either convict or acquit. And then for Clause 7 here, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. So this means that the maximum penalty for a conviction in the Senate of the impeachment means that they just are kicked out of office and can't hold any future office. That's the maximum penalty. But then it says, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So he's saying that the plain reading of this, now I don't know what the agreement is on this, he's saying that the plain reading of this is that, well, if you want to indict, trial, judge, and punish a person, like the president, it can only happen after a conviction in the Senate of a House impeachment. I don't know if there's like a broad agreement on that. I wouldn't agree that that's a plain reading, that that's the only way. I don't think that's a plain reading at all, because it seems like you're relying on the implied stuff from the vestment of the executive powers or whatever, and then you're saying, well, look, the only way you can do it is explicitly written here. But that's the argument that he's rolling with here. I don't know if there are, I don't know what constitutional lawyers say about that. I'm not sure.
Raising the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment.
Oh, okay. So she's giving, good job. Yes. Amy also, huge sub, tier 5 sub in chat. We talk a lot. So Amy's saying that, like, you can criminally charge anybody. Nobody's suggesting that impeachment is the gateway, as she says, to criminal indictment. You can be criminally indicted without being impeached, is what she's arguing.
Suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause doesn't say so?
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials, and he said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president.
Interesting. So only the president has this particular power applied. It's a unique power only to the president of the United States. Anybody else could be criminally charged, not the president, though.
Mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history. And what DOJ admits is the framers' intent. And so we say that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional structure.
What if the criminal conduct isn't discovered until after the president is out of office?
Yes, please don't let him wiggle from this. I really, really, really want to hear an answer to this. What if it only happens after he's out of office? Hold on. Please, I just want to hear the answer to this. Don't let him squirm. I need a sippy soy.
So there was no opportunity for impeachment.
We say the framers assumed the risk of under-enforcement by adopting these very structural checks.
No shot. Did he just say shit out of luck? That can't possibly be the argument. I'm slowing this down. No shot. That would be wild.
This novel context where it clashes with the constitutional structure.
What if the criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assumed the risk of under-enforcement by adopting these very structural checks. As Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Okay.
Oh my God. That's a wild statement. Train says you're manipulating XQC against Aiden. You can leave me a timestamp. I'll go over it later, but.
Okay, and the special counsel makes a point that I think is a pretty compelling one. You admit that if the president were successfully impeached, that he could be criminally prosecuted after impeachment, right?
Assuming the prosecution was for the same conduct of which he was convicted, not impeached, he must be convicted.
Oh, wait, what? So the president can only be criminally charged with what the impeachment proceedings in the House and the conviction of the Senate specifically dealt with? Those are the only criminal charges while acting as president?
The prosecution was for the same conduct of which he was convicted, not impeached. He must be convicted. That word conviction is right there in the clause.
Okay, granted. But you also say that these criminal statutes, unless they explicitly mention the president, don't apply to him. So how can you say that he would be subject to prosecution after...
Wait, is that plainly in the law? The Senate shall I'm just going to read this one more time. I'm sorry. Because he's reading a lot into these two clauses. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. And then again, rereading this clause, judgment in cases of impeachment shall not extend further than to removal from office and the disqualification to hold and enjoy any office of honor, trust, or profit under the United United States, but the party convicted, oh, it does say convicted, and it says judgment in here, which also applies to convicted. Okay, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. I wonder where he's getting the, I guess he's reading into it because it's not plainly stated here. Well, arguably, this is not plainly stated that you must be convicted in the Senate in order to face any criminal charges. But now he's saying that the criminal charges that you face after conviction in the Senate can only be about what you were impeached and convicted in the Senate for.
Don't apply to him. So how can you say that he would be subject to prosecution after impeachment while at the same time saying that he's exempt from these criminal statutes?
Well, there are statutes, as they concede, where Congress has purported to do so.
2 or 3.
They haven't done a comprehensive review. I think it looks like all they did was text search for president in 18 U.S. Code. Again, under Franklin, that's a very telling indication that the word president is not in the statute. It isn't necessarily a magic word requirement, so to speak. But more fundamentally than that, they concede there are statutes that exist. In addition to that, much impeachment could occur as a result of private conduct. So the impeachment judgment clause does do significant work by authorizing the subsequent prosecution of a president there, because what the framers, if you look at what they're discussing in the thing, or in the Constitutional Convention, is principally concerns about private conduct, which of course we concede are not immune.
Okay, so just to pick up Justice Kagan's.
Man, nevertheless, in spite of that, notwithstanding all the same, that is what nevertheless means. Is that really the reading of this? Does every constitutional scholar agree on this, or is this contested or debated? I don't think it's a plain reading at all of this, that the only way that, because what he's saying is that this clause is saying the only way to criminally charge a president is to impeach them first, and then for them to be indicted in the Senate. And his plain reading of that comes from this. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. I don't agree with that in plain reading at all. I think it says, I would almost argue it says the opposite, or it's ensuring you that you also still have the right to take them to trial. I almost feel like this is a protection from double jeopardy, basically, or like saying that like it's not double jeopardy if you take them to criminal court after the impeachment. That's almost what this feels like, more than a clause that says it's the only way to criminally indict a president, unless there's other constitutional lawyers or scholars that read this differently for other reasons. But yeah, I don't get that. I don't get that as a plain reading at all. But none of them have challenged him on that reading so far. It doesn't seem so, but maybe it'll come out.
Example of a president who orders a coup. Let's imagine that he is impeached and convicted for ordering that coup, and let's just accept for the sake of argument your position that that was official conduct. You're saying that he couldn't be prosecuted for that even after conviction and an impeachment proceeding.
You are bending over backwards for your interpretation. I don't know how you get there. What are you talking about? My interpretation is the plain reading of the English language here. What part of this implies that you can only indict somebody after an impeachment proceeding? There is no plain reading of that gets you here. You're implying stuff. A plain reading means that the language set forth as is describes what it is you're saying. If you have to bring in other parts in order to flesh out what this means, then it's no longer just a plain reading. Now you're getting into interpretive stances, I think. LOL, love it when Destiny thinks he's smarter than a judge. Hardcore Cetra, I'm sorry. What have I said so far that's contradicted anything that any of these judges have said? Pretty sure like 95% of what I've said they brought up eventually. What are you talking about? Okay.
If there was not a statute that expressly referenced the president and made it criminal for the president.
There would have to be a statute that made a clear statement that Congress purported to regulate the president's conduct.
Okay, thank you.
Justice Jackson?
So I think I now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of...
Wait, did we get away from the after he's out of office? How do we keep escaping this? I want this answered. Why do we keep getting away from this?
difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act, is being necessitated by that assumption. Because of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
No one will want to be president again if you can be criminally prosecuted for any little thing by the other party. Well, no, I'm sorry. You can't be criminally prosecuted in the United States for any little thing. You can be criminally prosecuted for criminal acts, which, as far as I understand, is a good thing. You should be criminal acts should be criminally prosecuted, ability to be prosecuted. That's a good thing.
Immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be made.
Right, but I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to...
Oh, no, wait, you're right. He did answer it. He said you're shit out of luck. If the president gets out of office, then just nothing happens. God, that's such a wild argument. So if you're a president, like, just commit crimes, I guess, like, in your last week or two in office?
We have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that.
Isn't what Biden's doing at the southern border a crime? Individually? What private act has Biden taken at the southern border? What could you even begin to call a private act there? Unless you've got video footage or accusations of him, like, sneaking around trying to let people in personally. What the fuck are you talking about?
Capacity. And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not. So why would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
The law, yeah.
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts. But the remedy for that is the question.
Impeachment.
Could he be subject to personal vulnerability, sent to prison for making a bad decision?
This is so boring. Is the rest of this going to be any different, or are we going to loop on these same stupid fucking points? I wonder. We'll see.
After he leaves office.
But other people who have consequential jobs and who are required to follow the law make those determinations
all the time
against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make...
Oh, that's true. We're going to get the state side of this soon. Which will be interesting.
Kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law, and if they don't, they could be sent to prison, et cetera, et cetera. So
I say two things in response to that,
Yes.
both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected in Fitzgerald.
No, but
Do they read super chats in the middle or at the end of this stream?
let me just, Fitzgerald was a civil situation in which the president actually was in a different position than other people because of the nature of his job, the high-profile nature, and the fact that he touches so many different things. When you're talking about private civil liability, anybody on the street can sue him, we could see that the president was sort of different than the ordinary person when you say, should he be immune from civil liability from anybody who wants to sue him? But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he is doing his job than anyone else.
He is required to follow the law. And what
But he's
Fitzgerald
not
said is
if there's no criminal if there's no threat of criminal prosecution, what prevents the president from just doing whatever he wants?
all the structural checks that are identified.
But but you said it yourself, there's no structural check at the end of his term. In the last month, he's basically free to assassinate whoever, personally murder or beat the shit out of whoever. Like, he can do whatever the fuck he wants because he can't be held to account unless he's impeached first. So if it's like the last day or two, it's basically like the fucking purge. It would make, I would say, for a very fucking funny movie where you live in a world where, like, the last day the president's in office, it's like a zombie movie or some shit, or like you have to just avoid the president at all costs because you know that whatever he does, he can't be held to account for. It's like fucking
I don't know, Groundhog Day, or some weird shit, but just for the president on the last day of office? Like the White House empties out, everybody's like running for their fucking lives.
In Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series of them. Fitzgerald directly addresses this in the civil context, and we think that language naturally ports.
I'm not sure that's much of a backstop. And what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled.
Yes.
If someone with
Yeah. Now she's giving the other side, because I've given this a few times. Like the extreme side is like, oh no, a president can be sued for anything. They're not going to take any brave actions as president. That's not good. But what about the other side, where a president can commit unlimited, unlimited criminal acts, but he says that they're all in the official capacity as president? Well, isn't that like equally or possibly even more terrifying, rather than a president over encumbered by criminal law, but instead a president completely unrestricted by criminal law?
An opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that
he had
there
no
would
criminal
be
liability,
no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
He's just going to say, well, there's a structure for that, and that structure is impeachment. He's going to repeat that again.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional.
He's just repeating the same shit he said before. It's not even.
And what George Washington said is...
Wait, I'm curious. What is the source of that Benjamin Franklin quote? Does anybody have that? I'm curious what he's referring to there. Benjamin Franklin quote... criminal prosecution, president. Fuck. I'm so curious what he. I'm so curious. He keeps referring to a particular moment in debate. I wish I knew what it was. I don't know what he's referring to.
Yeah. So what is the argument that the president of the United States, who you say is bound by the law, is not on notice that he has to do his job consistent with the law? I mean, to the extent that the clear statement rule comes in at all, it's about the person not being on notice. So I guess I don't understand why Congress in every criminal statute would have to say, and the president is included. I thought that was the sort of background understanding, that if they're enacting a generally applicable criminal statute, it applies to the president just like everyone else. So what is the clear statement that would have to be made in this context?
Under Franklin and under Public Citizen, Congress has to speak clearly before it interferes with the president's powers, and we have here an indictment that seeks to criminalize objective conduct that falls within the heartland of core executive authority.
The heartland of core executive authority is creating a false slate of electors to try to overturn and to lie about elections. That's a core duty of the president. That's funny.
Thank you.
Thank you, counsel.
Not even arguing that that's like a peripheral duty when we should just be safe and err on the side of caution, but that's a core duty of the role of the president. Okay. I think next is the arguments from the state now for this case. So it's going to be the argument saying that Trump shouldn't have immunity. The counter questions will be interesting. I'm going to use the restroom real quick. 1 sec.